When a parent in Arkansas registers property in the name of their child, Arkansas law presumes this transfer to be a gift, unless strong evidence shows otherwise. This principle is rooted both in common law and in legal tradition, and it carries significant benefits, risks, and some responsibilities. So we'll explore the legal landscape underlying this presumption, the advantages it can offer families, and the potential setbacks that can arise when intentions are not clearly understood or documented. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 500 company, and I've held positions within state government as the director of the Arkansas Department of Labor and the executive director of the Arkansas Fair Housing Commission. Now, I am the managing attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had families deal with this very issue, and I hope that this information provides some insight into how I provide my advice, which can be different for every family. Now, every family at some point faces questions about property and legacy. It may be a family farm, a cherished home, or a valuable piece of downtown property. When it comes time to pass these assets to the next generation, how we do so can have far-reaching consequences. It can affect not just taxes and paperwork, but also relationships and family dynamics. Here in Arkansas, courts look closely at the intention behind these transfers. The question becomes, was it a gift? Was it an advancement? Or was it a transaction for value? The answer determines whether the child truly owns the property, how it will be taxed, and what happens if there's a disagreement down the road. To begin, let's look at the core principle. Under Arkansas law, when a parent registers legal title to a property in the name of a child, the transaction is presumed to be a gift. This presumption is deeply anchored in state law. Courts have held that naming a family member, especially a child, on a property deed is presumed to be an act of generosity unless there is substantial evidence pointing to some different intent. This means that barring clear documentation or testimony to the contrary, our legal system assumes the parent intended to benefit the child freely and outright. To learn more about how we assist our clients with these and other types of legal situations, click below and let's get started today. Now, it's important to note, as stated under Arkansas law, that the intention of the parent is the key factor. Courts care far less about what the paperwork says, focusing instead on what the parent truly meant to do at the time of the transfer. Was this meant to be a simple gift, a pre-death advance on an inheritance, or payment for services or debts? Only credible, convincing, contrary evidence will rebut the presumption of a gift. Now, you may wonder, why would a parent choose to title property in a child's name during their lifetime? Well, there are some compelling reasons for parents to do so. Number one, estate tax benefits. The Arkansas Supreme Court has recognized estate tax motivation as a valid reason for parents to transfer property to their children. By naming a child or their children as the owners during their lifetime, the value of the property may be excluded from the parent's estate at death, potentially reducing exposure to estate tax and streamlining future planning. Number two, it simplifies the property transfer. If the child is already listed as a co-owner or sole owner after the parent's name is removed, the need for probate is reduced or eliminated, which can save time, money, and uncertainty for the family. Number three, facilitates lifetime gifts. Sometimes parents simply wish to help their children, perhaps by buying a first home, starting a business, needing financial security. The law allows lifetime gifts to be used to strengthen family bonds and offer concrete support, ensuring that assets are put to use when they're most needed. Now, of course, these benefits do come with some risk. So let's discuss those now. There could be disputes over the intent. If the parent's desires aren't thoroughly documented, family disputes can erupt. For example, children and other heirs can challenge whether a deed had truly been delivered, pointing to the parent's continued use and payment of taxes as evidence that no real gift was intended. When the facts are muddled, litigation often follows. There could be unintended consequences. Once a child's name is on a deed, he or she holds legal authority over that property. Although parents may retain beneficial use of the property, legal title was transferred to the children. That can set up friction if the child chooses to exert control contrary to the parent's wishes. This creates tension and can even deprive the parent of financial security if the relationship sours. And there's also exposure to creditors. Naming a child on a property doesn't just transfer ownership, it also exposes the property to that child's legal and financial risks. If the child faces lawsuits, creditor claims, divorces, the family property can be caught up as collateral, often far from the parent's original intentions. Given these stakes, what can Arkansas families do to protect themselves? Well, always document your intentions thoroughly, whether through clear deeds, written statements, or very clear communication to the entire family. Work with legal professionals to structure these transfers with the right blend of tax efficiency and legal clarity. If preserving control is essential, consider alternatives such as life estates, trusts, or payable on death designations rather than outright transfers. Give us a call today and set up a strategy session with one of our attorneys and let us guide you through this process. Now, something I want you to keep in mind. Arkansas law does presume a gift when the parent names a child on the title of property, but this presumption can be rebutted if there's clear evidence of another intent. The legal landscape is supportive of family generosity, but ambiguous and casual transfers often lead to family strife, costly litigation, and outcomes that nobody intended. When it comes to building and passing on a legacy, plan with full awareness of both the legal presumption and the potential consequences. Make sure to secure trusted guidance, document intentions thoroughly, and make deliberate choices that serve your family's goals now and in the years to come. Make sure to subscribe to our channel to learn more valuable information on building and securing your family's legacy.